Hello, everyone. Thank you for joining us. I'm here today to coordinate this United GIPs webinar series with Mr. Kshitij Malhotra, Managing Partner of Global IP India. Mr. Malhotra holds an engineering degree and has been working as a registered Indian patent agent since 2010. He also holds a Bachelor of Laws from the University of Delhi and has been practicing as an advocate in India for more than a decade. Additionally, he completed a postgraduate diploma in patent law from Nalsar University in India and received training at the Japan Patent Office in Tokyo in 2013. Mr. Malhotra has helped clients secure patents at major patent offices and offers advice on various intellectual property matters. He specializes in both non-contentious and contentious work, such as drafting agreements, IP negotiations, patent and trademark dispute resolution, and representing clients at patent offices, district courts, and high courts. For any questions or comments with today's webinar, please email Mr. Malhotra at kmalhotra@gip-india.in. Now I'm going to turn our presentation over to him.
Thank you, Crystal. So, thank you very much for your kind introduction. So, without wasting any time, let me get into the topic of today's presentation. Today, I will be speaking about working of patents requirement in the Indian patent system. Working of patents is a very unique requirement. I can't remember any other patent law which has something like a which has a similar requirement or a similar requirement. So according to section 146(2) of the Indian Patent Act read with corresponding rules, every patentee or a licensee of a granted patent is required to submit a statement regarding the working of a patented invention on a commercial scale in India. Put it very layman sense, as per this particular requirement, every patentee or a licensee of a patentee has to report commercialization information regarding their patents to the Indian Patent Office. This is very unique, not found in any other patent system. So one common question that arises is that what's the purpose of this requirement? So the purpose or the thought process of having a requirement like the working of patent requirement is that the patent office actually, by having this requirement, wants the patentees to or encourages the patentee to commercialize their patents. And also this by way of this requirement, there is the patent authorities have a mechanism ready with them at their disposal to keep a track of the commercialization information of various patents that they have allowed. The commercialization information is usually this particular working of patent requirement is reported under form number 27, and that's why this particular compliance is also called as Form 27 compliance. So let's take this particular example. And this is, please note that this is 15th March, before 15th March 2024. That is 15th March last year. This particular the system of reporting was like this, but I will just give you an idea by way of this example of what this particular requirement is and how this requirement is usually or how this particular reporting system works. Now, if there is a granted patent, say allowed by the IPO, then all the commercialization information goes under Form 27 and is filed as per few due dates. Now, if a patent is granted, this is again before 15th March 2024. If a patent is granted, say on 1st August 2021, I'm sorry, and then, this as per this requirement, a Form 27 reporting has to be done corresponding to this patent, granted patent at the IPO by a due date of 30th September 2023. That is, but within 6 months of the end of the next financial year for a previous financial year. So grant date is 1st August 2021. And as per this particular requirement, the commercialization information in the financial year in which the patent got granted is usually excluded and not required to be furnished. But In the next full financial year, whatever commercialization has happened is required to be furnished by way of filing a Form 27 corresponding to this patent within 6 months of the end of the financial year for which the reporting is to be done. There were many issues that patentees used to face with respect to Form 27 compliance. And actually speaking, we work with a lot of clients and it was a big headache for them to comply. There were certain ambiguities also in how to meet these requirements. And because of that, we are always, as patent attorneys, had our hands full when it came to meeting the compliance. So some of the issues was that since it was a yearly requirement, it was very burdensome on us. The formality required to be submit is required submitting certain complex and sometimes confidential business information, such as details of licensee names corresponding to the granted patents, quantity of patented goods manufactured, imported in India corresponding to these patents. So you can well imagine that if information, such critical information like number of items which has been manufactured or imported has to be reported, and this information comes in public domain, then it's usually sensitive for the patentees to furnish this information and to meet this compliance. Also, there was no provision for joint patentees or co-patentees to file one single Form 27, again making this requirement very burdensome. And also, non-compliance could lead to a lot of pecuniary or monetary, fines. And there were provisions of even penal or incarceration of up to 6 months in jail in case some false information has been reported intentionally by any patentee while meeting this particular requirement. So again, there was a lot of debate or a lot of discussion around meeting Form 27 compliance, where the patentees were very skeptical in terms of both the taxing nature of the requirement as well as in terms of what kind of information was reported, which many patentees believe was very sensitive. And not to mention, if false information was reported intentionally, then it could even lead to penal consequences. So, but last year there were some changes made to this particular requirement, and these were introduced with effect from 15th March 2024. And some of these required changes are as follows. So earlier the requirement was furnishing statement every year for the commercialization details with the commercialization details of the previous year. But now it has been moved from one yearly reporting to once 3 year reporting. So this is first significant change. We'll come to how it will benefit later on during the presentation, but this is the first major change. The second major change is that earlier there were no provisions as to extension of filing Form 27. So Form 27 due date, as you could see from my initial slides, was 30th of September 30th September of every year for the financial commercialization information for the commercialization or the working that has happened in the previous year. But now, but now, uh, and there was no extension to it, but now there has been a provision or there has been provisions provided in the amendments by way of the amendments where certain extensions have been awarded to the patentees while meeting this requirement. We'll come to what kind of extensions are these. Also, now one Form 27 could be filed for multiple patents, as well as co-patentees can now combine and file one single Form 27 for their patents. Most importantly, and I have put these next few changes in italics because these are the most significant ones. there has been a reduction in the amount of data that is now required to be reported. For example, now no data regarding value revenue accrued in India by manufacturing and or importing of the patented invention is required to be furnished. And also requirements for providing details of licensees, sub-licensees also done away with. So these are the two main developments, in my opinion, that has happened. That is now the value as well as quantum of the patented products that have been imported in territory of India or manufactured or sold locally, that is not required to be furnished anymore. Another main change that has happened is that now the penal consequence of furnishing false information that has been completely scrapped or done away with. So, by way of Jan Vishwas Amendment of Provisions Act 2023, the penal provision under Section 122 as to furnishing false information in Form 27 is completely scrapped. Okay, so let's so this slide talks about the old format, new format, what kind of both put together side by side to see what kind of changes have been incorporated. So this is the earlier Form 27, which was from 2020 to March 2024. And this is the format of Form 27, which is applicable now. The main difference you will see is in column number 4 and column number 5. In column number 4, earlier approximate revenue value accrued in India to the patentee's licensee furnishing the statement from patent numbers where the working is through. Manufacturing or importing was required to be furnished. That is revenue value accrued of the patented products that have been either manufactured or have been imported in the territory of India on a commercial scale. All that value needed to be put into that particular Form 27 in case the patent has been worked. And if not worked, then reasons were to be given as to what are the steps that have been taken. Now you will see on the right hand side the new requirement points 4 and 5. All this quantum value and quantum of the patented products that have been either manufactured in India or imported in India, that requirement is completely done away with. And regarding non-working also, no declaration or no statement as to what steps are required for working that has been put. So again, to summarize, old requirements versus new requirements, pre 2000 amendments, that is pre 2014, 2024, and I'm extremely sorry. The requirement was yearly compliance, but now it has been once 3 years requirement. Uh, there was no provision for extension previously, but now provisions of extensions are given. And this quantum of extension, that is, any patentee can seek 3 months of extension from the Form 27 due date with another 6 months allowed on furnishing of additional fees and on the discretion of the patent controller or the patent office. Furnishing of any false information intentionally could be a penal offense, but post 2024, it's not a penal offense anymore. That is furnishing false. Of course, there is penalty with respect to non-furnishing this information, but all those penalties are of monetary nature and not of penal nature. Co-patentees earlier could not combine and file one statement, uh, one joint statement, but now joint statement regarding commercialization info is accepted, and these joint patentees can file such combine their statement and file. Earlier, details such as details of licensees, approximate value, revenue accrued from the patent was required to be reported. Now there is no such requirement. However, despite all these changes, I mean, a clear sense from this particular slide number 8 is, and my presentation is that this new requirements or the new laws or the new amendments that the amendments, recent amendments that have happened last year have kind of relaxed the requirement of reporting by, of course, as you can notice, from an yearly compliance, it has moved to once a 3-year compliance, which in itself is a big relief for the patentees in terms of both, the requirements of giving that information as well as monetary relief of filing every year yearly statements. Now, once 3 years only, this particular statement is required. But along with all this relief, there is some still confusions or some kind of apprehensions that still exist. Some confusion. So this particular slide talks about some issues or confusion with respect to new requirements, that is post 2024 amendments. First particular issue is regarding confusion which exists regarding deadline and extensions. But last year, the Indian Patent Office came out with a very elaborate, white paper or a very elaborate notification explaining what what are the deadlines like and what are the extensions like available. So the deadline is that so it's very much clear that as per the notification release that the working of patent is only now a 3-year event rather than yearly event, and is the deadline for filing is also extendable. So it can be extended to 9 months with the 3 months under Rule 131(2) by filing a normal extension, and 6 months discretionary extension, which can be given by the Patent Office under Rule 138. Okay, so another confusion or another discussion point or another apprehension that has come up is that the new Form 27 does not require detailed information about the extent to which working of patent has met the public requirement. So this is a concern mostly from the domestic applicant sides or domestic, from the domestic angle. That is the domestic, companies in India, they feel that since the level of requirement of providing, some detailed information of about what steps are, what steps a patentee is taking in order to commercialize their patented invention, that information is not required. So there is some kind of leeway or some kind of relaxation that has been given. Then new DOM Form 27 does not require patentees licensee to furnish details about existence of licensees and sub-licensees. So this is also some issues that some voices have come up and they have protested against, or the new requirement not requiring details of licensees to be furnished or sub-licensees to be furnished. And so many believe that these new requirements are easy to comply. This is mostly from the patentee sides, but from the sides of the domestic audience, they believe that the requirement of the provisions that are amended provisions, uh, they they have diluted the entire thought process behind introduction or of this working of patent requirement in the Indian patent law. So jury is still out on these new amendments. Thank you. Thank you very much. And with this, I would like to conclude today's seminar. In case you have any queries or questions, you please feel free. My email ID is kmalhotra@gip-india.in. If you want, I can just write it down. You can reach out to me on this email ID if you have any further questions. Thank you so much.
Thank you, Mr. Malhotra, for your presentation today. Thank you, everyone, for tuning in to today's webinar series. Please remember, for any questions or comments, please email Mr. Malhotra at kmalhotra@gipindia.in. We will see you soon at the next webinar.